billion shillings and further amounts of money towards causes that do not add value to the people of Kenya. What does this demonstrate? It demonstrates a failure of leadership. And when the Chief Justice advises the President of the Republic of Kenya to dissolve Parliament, the Chief Justice does not act on his own. He acts on behalf of the people of Kenya. And similarly, when the President of the Republic of Kenya is required to dissolve Parliament, he does not do that as a fiat. He does that as a delegate of the people of Kenya. It follows, therefore, that if the President fails to act in accordance with the will of the people of Kenya, he has violated the Constitution. And this will not be the first violation of the Constitution by His Excellency President Uhuru Kenyatta. It is a culmination of many acts and omissions of violations of the Constitution. I can only mention one: the refusal to swear in 41 judges, which has persisted for almost a year now. And what does the President of the Republic of Kenya tell you? He goes to a hotel in Paris before a French journalist in the midst of his quest to go and burden you with more debts through loans, that the matter is now pending before court. I will not act until it is otherwise determined by the court. Let me tell you two instances where a similar statement has been made before. This statement was made in 2008 when the election of President Uhuru Kenyatta was contested. What did they say? Go to court and have it determined, because they were certain they had control of the courts. They made the same statement in August 2017. Go to court and have the matter determined. Why? Because they knew they will either control, coerce, cajole, or compromise the judicial process. And when they did not succeed in doing this in 2017, they promised to revisit and fix the judiciary. It is on this backdrop, therefore, Kenyans, that you must appreciate the statement from the President of the Republic of Kenya that let the matter be determined by the court. Where does he get the assurance that the matter will be determined in his favor? This is the assurance. They have revisited and fixed the judiciary. It should concern you that several state organs, state agencies are suing each other before one state organ. Does it really make sense that the Attorney General will originate a case against the Chief Justice, the Speakers of the Senate and the National Assembly, and on the other side, the Speakers of the National Assembly and the Senate will originate another claim against the Attorney General and the Chief Justice? And where are the 6 petitioners on whose behalf, as representatives of the people of Kenya, the Chief Justice acted? They're nowhere. The intention is obvious: to compromise this litigation. And it must be understood that the President himself gave a directive in the month of July that there shall be no suits between state organs or state agencies. What has changed? The Constitution was not intended to be challenged before a court of law. None whatsoever. This morning, Justice Weldon Korir has delivered a ruling in respect of the election of the member of National Assembly for Gatundu North. And he has said a constitutional provision cannot be challenged before a court of law. What is it that these state organs and agencies are brought before a court of law? They want to determine what is public interest. They want to determine what is the meaning of the word shall. Really? The meaning of the word shall, to be determined by people who claim to be the advisors of the government of the Republic of Kenya? logic has been turned over its head. We respect the authority of the judiciary, but we cannot be put in a position as the people of Kenya where those who hold the highest responsibility of violating the constitution and disobeying court orders now want to take the people of Kenya to court and burden them with court orders that they have obtained through coercion, connivance, and compromise of the judiciary. This cannot happen, the people of Kenya. It is for this reason, therefore, that we want to hold all the three arms of government accountable, commencing with Parliament. Parliament ought to be dissolved by 12th, failing which we will occupy it with a vacation notice issued to the parliamentarians. And you, the people of Kenya, must play your role. You must call out your elected members of National Assembly and the Senate. Tell them they are in office illegally. They have no business to transact. We want you, the people of Kenya, to talk to our partners, local and international, and tell them the Parliament of the Republic of Kenya cannot offer oversight in respect of the loans that President Uhuru Kenyatta is taking day after day. And I want to tell the government of France, the people of Kenya will not be held liable on this loan that they have given President Uhuru Kenyatta. They may as well recover that loan from President Uhuru Kenyatta personally, now or when he leaves office. It is as simple as that. Let's go now to the executive. The executive must act in the best interest of the people of Kenya. We have seen the suppression of the right and freedom of speech. We have seen the curtailment of the right and freedom to associate, the right to picket, the right to strike. Why? Because the executive does not want the people of Kenya to benefit optimally from the rights due to them under the Bill of Rights. Why can you explain at this particular point in time why a leader requires a permit to speak to his people? Why a leader requires a permit to hold a public rally? And these fetters are being put, yet these rights are given under the Constitution. So the executive must be held to account. What about the judiciary? We stand for the independence of the judiciary, and we want all the people of Kenya to stand with Chief Justice David Maraga and all his judges to ensure that they are able to give determinations on matters amongst the people of Kenya and between the people of Kenya and the state without fear. Because as we speak right now, I know as a matter of fact that the judges are under fear on how to deal with the cases in respect of the advisory of the Chief Justice. May I encourage you, judges, do the right thing. The people of Kenya will be behind you, as were the people of Malawi when the judiciary did the correct thing. Way forward, on the 12th of October 2020 at 2:30, these friends assembled here will visit the two clerks of the National Assembly and the Senate and the speakers, if they will be there, to issue them with a notice to vacate. Over and above that, as we disperse from here, we want to travel all over the country and speak to the people on the need to exercise their sovereign power. On my part, I'll commence my tour with Western Kenya tomorrow morning. I'll be in Busia at 10 a.m. I encourage you to come out in large numbers. Advocates, professionals, their leaders, well-meaning Kenyans. At 12 noon, I will be in Bungoma. At 3 p.m., I'll be in Kakamega. At 5 p.m., I will be in Vihiga. What message are we putting across? Dissolve or occupy Parliament. This has to be done here and now. Not tomorrow, not the day after. Those who claim to lead must yield to the demands of those who hold sovereign power, the people of Kenya. We will take a few questions. You will field your question to whoever you want to answer it. Thank you. You will say your name and then you will pose your question.
My name is Leonard Omolo from West TV. My question is about what is your take on the Minister for Education to open schools on Monday?
I will defer that question to Honorable Jonathan. Jonathan, you will answer that question. Next.
What you like to ask this question? We are living in a country that keeps on disobeying programs. Come 12 to this month. If I told the government will not dissolve the parliament, we go occupy the parliament, we find their security officers. Do you feel we shall actually witness some sort of chaos come to the 12th of this month?
I will take that one. Next one.
Do you believe that dissolution of parliament will cause a constitutional crisis in the country?
Okay. I'll also take that one. Okay. Marilyn will take that one. Next. Or we answer those first? Okay, fine. We'll start with you, Marilyn.
So if I heard you correctly, the question is whether dissolution of parliament will cause a constitutional crisis. And I think you've heard us say that the constitution itself does not envisage a challenge to its legality or its validity. A constitutional crisis will only exist if we continue to have institutions of government purporting to act under the constitution but not bound by it. So a constitutional crisis will exist if we do not dissolve parliament, because if we do not dissolve parliament, then we are acting outside of the constitution of Kenya and we are essentially in no man's land. So if we do not dissolve parliament, we have a constitutional crisis. And please remember, this parliament has been illegal since 2017. So the dissolution is related to the failure to enact legislation. However, the illegality of parliament predates the dissolution order. It goes back to 2017 because it is illegally composed. So the constitutional crisis is in the hands of the president. Should he fail to dissolve parliament, then we do have a constitutional crisis.
On schools reopening, an announcement has been made that our children should go back to school. What concerns us is there is no plan. They are called to school today. The teachers have been in school for 2 weeks. The president said schools can't open without a plan. Now we hear schools are opening without a plan. Are there plans in place for teachers to be tested for COVID-19? Are there plans in place for our children to be tested for COVID-19? What is the plan to ensure the health and safety of all those who work in schools? Have the parents been consulted? Can they afford to take their children to school? Have they planned adequately for this burden? Somebody just can't wake up in the morning and off the cuff decide that he's going to do whatever he wants to do. That's not how a country or an institution should operate. So we have to ensure that a solution be found for our children to go back to school that makes sense. And it is the responsibility of the government, because it has been elected by the people, to work for the people. They should put together all the resources at their disposal to ensure that they find this solution in consultation with all the stakeholders in the education sector. So our position is you just can't have knee-jerk reactions to the future, the health and the safety of our students, of our teachers, of the workers in all the schools, and anybody else who is a stakeholder in our educational system.
I will take Khaemba, is it Khaemba? From Ebro. I'll take Khaemba's question, then if there is any other questions, you'll ask them. We'll allocate them amongst ourselves. Your question was, this government has distinguished itself in the disobedience of court orders and violence, and whether we will be meted with violence when we visit the two clerks of the Senate and the National Assembly on the 12th of October 2020 at 2:30. I believe that was your question. Well, you have put it in ways that are much better than I'll have put the issue. We are not asking the people of Kenya to revolt. This is not a revolution. This is an assertion. What are the people of Kenya asserting? They are asserting their sovereign power as given by the Constitution. And to that end, therefore, the enterprise we propose to take effective today, and in particular on the 12th of October, is a legal enterprise. It cannot be subject to criminal sanction. We will proceed there in a civil formation within permissible numbers and in an orderly way to seek audience with those two state officers. And we hereby notify the Inspector General of the National Police, my very good friend Hilary Mutyambai, not to waste public resources by deploying their tanks, by deploying their armed policemen, because we are all law-abiding people. We are going for a civil mission. We do not therefore expect that there will be violence. On our part, we want to encourage all Kenyans who want to participate in the assertion of their sovereign power to exercise it within the confine of the law. We are living in a modern world where revolutions cannot be the order of the day, where we do not take arms, where we do not resort to violence. The Constitution has given us a very elaborate way of exercising power through delegates or directly where delegates have failed. And that is what we ask Kenyans to do. Act within the confine of the law. Mr. Honorable Neto will take the subsequent questions. Ongeza sauti tafadhali.
Sasa ningependa kuuliza iwapo katiba ya Kenya na bunge ama Rais Kenyatta atakosa kuingilia bunge la kimamlaka. Ninyi kama wanasheria mtafanya gani? Nikiongezea kwa hilo, iwapo kipengele cha katiba ya Kenya ya 2010 kifungu cha 18 kifungu cha 221 ibara ya 8 6 na 9 itakosa kufanya kazi,
nitajaribu kuongea Kizungu kwanza alafu baadaye nitajaribu kwa Kiswahili. But let me just say a couple of things first. My colleague Jonathan said we are here together as the United Green Movement Party. We are 52% and the Law Society of Kenya. First is to acknowledge the fact that we are law-abiding citizens. The Law Society of Kenya is the crucible of law in Kenya, so they should and ought to be law-abiding citizens. The United Green Movement Party is a political party that believes in non-violence. It's part of our political philosophy. Now, to the question that you asked whether there's going to be a constitutional crisis, we invite you to listen to lawyers from the Law Society of Kenya and those ones that Mr. President has not registered from being members of the Law Society of Kenya. The Constitution of Kenya at Article 261(8) presupposes that upon the dissolution of Parliament, there will be an election, and that election is to a 5-year term, and the term of that particular election is therein in the Constitution anticipated. People say that there's going to be a constitutional crisis because they refer to the aspirations of Article 102 that the election of Parliament should be also within the meaning of the election of the presidency. That is not true, because if you look at the Committee of Experts report on the Constitution, they had anticipated a Parliament that would have gone rogue, like this particular 12th Parliament. And that is why it was put, the person who is on the offensive is the House of Parliament. It will be dissolved, and the people of Kenya shall elect a new Parliament, and the term of that particular Parliament is therein in the Constitution contained. So there's no vacancy, there's no crisis. That's the first question. As to the second question, with regard to whether we expect to have violence on the 12th, and Mr. President has of course responded to it. But let me say this. As the United Green Movement Party, alongside us, the Law Society of Kenya, did issue a notice to vacate. Now, we are going to Parliament on the 12th in a civil manner to tell the tenant, who is members of Parliament, represented by the clerks and also the speakers of the National Assembly and the Senate, that they are illegally occupying our house. And like we said, we are lawyers and we are law-abiding citizens. We are giving them a framework within which we will have a conversation with them on 12th, very civil. We are not asking Kenyans to just come to the streets as yet. No, we will get there. Because as Mr. President has said, sovereignty belongs to the people. We will do every practical step as is required by law. We have issued a notice to vacate. We will give them the notice now that it's time to leave. We'll give them a couple of days. And we know for a fact, and you've said it, they are up to disobeying court orders from time and time again. We shall help Kenyans gain back the rule of law. Sasa kwa kuambia kwa kifupi ni ya kwamba tunasema ya kwamba sisi ni Wanakenya ambao tunaheshimu sheria. Na vile vile sisi ni wanasheria. Hatutaki kufanya ya kwamba kutakuwa na malumbano yoyote na wanasheria au askari polisi. Tunasema ya kwamba katiba lazima itimizwe, na tunasema ya kwamba kipengele cha kwanza cha katiba inatuambia ya kwamba Wakenya ndio wako na uhuru na jinsi ambavyo wanataka ya kwamba katiba itekelezwe. Tunasema ya kwamba wasipotekeleza katiba kwa vile tunataka, hakimu mkuu tayari amewaambia ni vizuri wajue ya kwamba kama wataka kuitimiza tutatumia kipengele cha 37 ambayo inatuambia ya kwamba peacefully and unharmed Kenyans can walk and get to make demands that parliamentarians vacate. Fellow Kenyans, that is a call we're asking you for. I do not want to take so much time. Mr. President only asked me to come and respond to those questions. The notice to vacate on the 12th will then be followed by sets of activities, like the President has said, until this particular Parliament goes home. And when it goes home, fellow Kenyans, we must elect responsible leaders to the House of Parliament, because that is what the aspiration of our Constitution. Thank you very much, Mr. President.
I have a question. One might wonder, like, if law-abiding citizens, there is an active court decision suspending whatever the advisory given by the CJ, one would be wondering what's so difficult in waiting for the execution of whatever they are doing?
Well, as I stated before, the issue insofar as the advisory by the Chief Justice is concerned has the protection of the Constitution. The Chief Justice's decision cannot be challenged in a court of law, and whoever has gone to a court of law on this decision has only two intentions. One, to delay the eventuality of the obvious dissolution of Parliament, and two, they could only be going to court when assured of an outcome. Look, it is not the first time that a judge of the High Court of Kenya, the Court of Appeal, or the Supreme Court makes a decision that is inconsistent with the Constitution. As lawyers, we know these incidences abound, and it's for that reason that we have stood here to stand in solidarity with the judiciary. We are not countermanding the legal process. We are pleading with the judiciary to make the correct decision and we know what the correct decision is. You cannot tell me the Chief Justice can make a decision which a High Court judge will find to be inappropriate. No, it can't be like that. We therefore ask the judges to take into account a very fundamental fact, in fact two. One, that the 6 petitioners who are the Chief Justice to dissolve Parliament have not been taken to court. So what is before court? And 2, arms of governments cannot sue each other. It is simple as that. It is worse than incest. We cannot condone it.
I really would like to emphasize this because it's really important that the media understands. What is in court is the Chief Justice's advisory opinion. What is not in court, and it is not controverted, is that the 12th Parliament is unconstitutional. And per Article 3(2), it is unlawful. Okay? So please separate those two issues because they are distinct. And when we are speaking about an unconstitutional Parliament, we are speaking about a matter that has existed since 2017, and it is uncontested and uncontroverted. Okay? And we are not asserting that we are in any way countermanding the court process, as Mr. President has said very clearly. But it is also important that you report to Kenyans the facts as they exist, which is that an unconstitutional body is seeking protection of the Constitution. Where does that happen? What framework allows an unconstitutional body to seek protection of the same Constitution that it is violating? And that's a distinction that I think is really important that Kenyans understand. Thank you. I think we're done, right?
Yeah.
You want to say thanks?
Thank you so much. Please give this issue the coverage it requires. We rely upon the media to inform Kenyans, just as we rely upon leaders to provide guidance and upon lawyers to give legal direction. We have given you all this. Thank you so much. God bless you.